everyone. Thank you for joining today's conversation with Barriston Law on how to keep your transactions moving during the pandemic. My name is Danielle. I'm the Managing Director and one of 5 team members here at the Sandbox. For those of you that have not been acquainted with the Sandbox is located in downtown Barrie, Ontario, and we connect people and their ideas to business resources through collaboration and sharing knowledge. So before we jump in, just a few quick housekeeping notes. As you can see, all the attendees are muted. So if you have a question, please use the Q&A feature on the bottom of the window, and I'll be facilitating a Q&A session later in today's session. Once the presentation is over, attendees are going to be sent a link to access all of the presentation resources on our website. I'd also like to thank all of our community partners for supporting with the sharing of our events, like the Barrie Chamber of Commerce, Community Development Corp in Aurelia, also known as CDC, Accelerate Her, and so many more. We really appreciate your support. A final thank you to our sponsor, Barriston Law, for delivering this session today. Janice and Lisa are on a mission to help the business community navigate through the rapidly changing landscape we're faced with. And with that, I'll hand it over to them to get us started.
Thanks, Danielle. So welcome everyone. Lisa and I are very pleased to be here and speaking with you today about the best ways and some tips and tricks that we found to help keep your business transactions moving forward during these uncertain times and throughout the pandemic. We will be covering a wide variety of different types of transactions today. And as Danielle mentioned, if anyone has any questions about specific transactions that they are currently undertaking, please throw us your questions. We welcome any questions or comments. And we hope to touch on sort of the broad topics that we think will be particularly helpful to anyone participating today. But we're happy to get into detail. So right now, I think all sorts of businesses are doing everything they can to help keep everyone's deals moving forward. And law firms and banks are no different. And of course, we've got different entities that are private who are still able to conduct business. So I know that there are different deals of all shapes and sizes and different details that are specific to each different entity that need to be considered. And so we're happy again to field any questions. So Lisa, did you want to kick us off today?
Absolutely. Thanks, Janice. Hi, everyone. So Janice and I, like she mentioned, we're going to cover a broad range of things, but I think the thing to start with is sort of how we're getting things done in the time of COVID and physical and social distancing. So as you may be aware, legal services are considered an essential service. So our law firm is still up, running, open to the public in terms of business. However, we're not accepting clients into the offices the way that we normally would. So if somebody needs to attend at the office, we're requesting that they call and make an appointment. We have a secure drop box if people need to leave documents around. Those sorts of things are in place. I would say the majority of our staff is now working remotely, Janice and I included, as you can probably tell from our screens here. And we were pretty much set up to do it from the get-go, so we're really grateful to our tech team for that. And apart from small nuisances like new coworkers, such as my cat, who likes to just fly all my paper off the table, everything seems to be going pretty well. One thing that's been interesting is the changes that the Law Society of Ontario has made as a result of COVID-19. So there's always been sort of that question from clients as to why can't we sign documents remotely? Why can't we do it by video conference? We've had the technology in place for a long time. Why hasn't it been permitted? And one of the biggest stumbling blocks for that were statutory declarations or sworn documents. So in a number of transactions, there are documents you need to swear in front of your lawyer or commissioner of affidavits and oaths. And when you swear it, it's the same as if you were swearing it to be true in a court of law. And the Law Society took a very strong stance that that was not permitted to be done by video conference. We still were required to be physically in the presence of the person who was giving that testimony. So with COVID-19, they have relaxed that rule. We are now permitted to do that remotely. So that's really helped us to be able to administer pretty much the same services that we were doing from the office, but remotely to you. So we're doing things like using Zoom for our client meetings. All of the lawyers are set up with Zoom accounts. It's nice because, as you know, it's pretty easy to get onto Zoom and speak with the person you're dealing with. For those people who might not have the technology available to them, whether it be they don't have a camera or a microphone or a smartphone, or their internet service isn't good enough, Barriston has set up a virtual signing room. So it's separated from our standard offices on a different floor. We have really strict protocols in place for when you can access it and how you access it. And the room is being sanitized after every use. Pens are going with people after they use them, all those sorts of things. So we're really being cautious about stopping the spread of the virus as best as we can, but still allowing people to access legal services. So I think that like other firms and businesses, we're all adapting our practices. Deals are still getting done. It's just a bit of a difference in terms of how they're getting it done. So with that, I'll let Janice sort of expand on that point.
Sure, thanks, Lisa. So as Lisa mentioned, it's law firms, it's all businesses that are changing the way that they're operating. And one of the big stumbling blocks, as Lisa pointed out, was the Law Society's position on having to physically be in the presence of a commissioner for the purposes of swearing affidavits or oaths. And they've relaxed that, at least for this particular period in time. But of course, law firms aren't the only entities and institutions that are involved in getting your commercial transactions completed. So we have seen banks start to change their own internal policies as well. So until recently, many banks would require what are called wet signatures to be in the possession of a lawyer before they would advance funds that were required to complete the purchase of either real estate or a business. Some banks are beginning to relax those restrictions right now. What we have seen are lenders asking lawyers to sign a statement to the effect that they were in the presence of the individual who signed particular documents or statements, or that they've complied with the Law Society's rules and regulations surrounding commissioning or administering a witness signature on a document. And so that really has made everyone's life a little bit easier when you're dealing with a commercial transaction. That flexibility in banks is very important. So if you are in the midst of, or you're about to undertake a transaction that does involve a lending institution or any kind of financing through a private lender, I think it's important to sort of ask the question at the outset, what has changed in your practice? Or is there anything that you will require prior to closing that might be a challenge in times when social distancing is a required protocol in society? And having those kinds of conversations really goes a long way to providing you with comfort, knowing that you've sort of covered your basis and you should be able to proceed on a fairly good, rapid schedule towards closing your commercial transaction, and that you will not have to expose yourself to any situations in which you're uncomfortable, or you might be exposed to somebody who isn't practicing social distancing. So seeing those sorts of policies with the banks start to change has been significant for those of us practicing law and for those that are undertaking commercial transactions currently, whether that transaction, as I say, is the purchase of real estate or the purchase of another business. Now, of course, with that, there are some challenges that have presented themselves. So we are seeing banks start to close certain branches or restrict their hours, and that's, of course, being done to help keep their staff members safe and to respond to a number of staff who aren't able to come into work. So that does pose some challenges. But again, we're starting to see banks start to accept wires or electronic funds transfers for payments of amounts that are owed in the course of a commercial transaction. There are fewer lenders that are taking on those kinds of policies, but we are starting to see some flexibility there. And hopefully we will see more and more innovation surrounding how funds can be sent between lending institutions, law firms, and private corporations in a way that is secure for all parties, but that also helps minimize our need to rely on physical visits to a bank branch. One of the things, and I'll leave this to Lisa to discuss, because it actually, I know, Lisa, you ran into this problem, I think just last week, with government institutions. Some of the searches that are performed at the time a real estate transaction or business purchase is occurring some of those searches actually require a physical person to go through physical records. And so Lisa, I understand that you had a challenge getting I think it was a bankruptcy search last week?
Yes, that's right. So whenever we're dealing with a corporation or an entity, basically you want to do your searches to make sure you know who you're contracting with and that they have the legal authority and the right to enter into such a contract. So one of the standard searches that we do, and it's one of those things that's a no-brainer as you're doing a standard transaction, is you do a bankruptcy search. And those are done at both the federal and the provincial levels. And yeah, we were sort of surprised and hadn't really thought about COVID affecting this when last week we tried to do our provincial bankruptcy search, and the response came back. I wrote it down because I found it interesting. Search failed due to the inability to attend the court due to COVID-19. Search may be reordered once restrictions are lifted. So that's one of those things where we don't necessarily put our minds to how certain searches are being affected, but for provincial bankruptcy searches, for instance, you do have people physically going to the courthouse to perform that sort of search. So those things are not permitted right now. We really are in sort of new waters here. It's pretty unprecedented, the situation that we're finding ourselves up against. So it's up to us to come up with strategies to get around this sort of thing. So Janice and I were sort of chatting about it, and I mean, certain things are available as a workaround. For instance, something like this, we might get a sworn declaration from an officer of the corporation confirming that they haven't entered into any sort of bankruptcy proceedings. And that might be sort of the best you can do for now, with an agreement to have the proper searches done once things normalize, and make sure that everything is in effect then. You're also going to see it with certain real estate searches that are required. So if you are purchasing, say, a commercial piece of property and you've got your transaction taking place, for the most part, they're title insured, and I'm not going to go into what title insurance is right now. It's sort of a whole other topic, but as part of that, there are certain searches that need to be done in order to get coverage. So for instance, if you're buying a property that has multiple units, you need to have a fire search done, a fire inspection done to make sure that the property is up to code. And that's one of those things where we wonder whether that will actually be available at a time like this, whether they're actually going to be sending inspectors out. I know that they're not going to be sending out people like building inspectors to make sure that people can get occupancy of properties and those sorts of things. So it's just something to keep in mind. The things that we took for granted as sort of a simple step in a transaction may be what presents us with a bit of a difficulty and requires a little bit of creativity on everybody's part. So I think that sort of briefly touches on real estate. Maybe Janice, you could chat a bit more about some things that we're seeing in real estate transactions.
Sure, Lisa. And then I think I also just wanted to mention that in the conversation we had earlier, we both sort of touched on the point that due diligence is going to be really, really important, or at least the importance of it will be highlighted in these times for reasons like provincial bankruptcy searches not being available. When you are looking to, if you're looking to purchase either assets from a corporation or shares in a corporation, it is of course typical to examine financial documents, but now you may be asking for the ongoing financial statements of a corporation up to a date that's perhaps closer to the closing date than you otherwise would have relied upon in past transactions. And it will also be important to make sure, if you're selling a business, that when you're looking at your representations and warranties, which are typically found in the agreement where you're agreeing to sell your business, that you're not making statements like business is going on as usual right up to the date of closing, or that you are at least softening that language to account for the current situation. So there are nuances, as Lisa said, about what was standard previously and what needs to be done to address some items that in the past would have been taken for granted, but really should be getting some attention now, and there's a bit of finessing to do with those kinds of provisions. And this applies to both transactions involving businesses, but also real estate. So in Ontario, most real estate transactions occur and they flow from an agreement of purchase and sale that is typically a fairly standard document and has things that outline provisions to do with realty taxes and the right of a purchaser to visit the home on X number of subsequent occasions leading up to closing. We are seeing, of course, some impact of COVID-19 on the real estate market right now. but I know that our office has still been receiving quite a few real estate transactions, ones that come from deals that were signed before the declaration of the state of emergency, as well as agreements that have been formed after that in the wake of social distancing protocols. And so the real estate market is still moving forward. There are still houses being listed and houses being sold. It is important, of course, to take a look at that standard area form and make sure that it still allows you the flexibility that you need, either as a seller or a buyer, in these current situations and current times. So some things that you'll want to consider, of course, if you're selling. Well, right now the municipality has different policies with respect to real estate taxes, but that doesn't mean that when you agree to adjust your housing price on closing and you agree to pay your taxes right up to the closing date, you will still, of course, have to actually pay your property tax up to the date of closing. So we got a question about that the other day. I just wanted to clarify. It's different. Just because the municipality may be deferring property tax payments and haven't billed them doesn't mean that you still won't have to pay property tax up to the date of closing. You'll do a calculation, or your lawyer will do a calculation to facilitate that payment. And then the right of the purchaser to revisit to inspect the property, and whether they still have that right is another question we've been getting. And if your agreement does allow them to visit your home 1, 2, or 3 times before the closing date, they do still have that right. It is a contractual right that you've consented to in entering into that agreement. But that doesn't mean that all parties can't be reasonable. And it doesn't mean that the purchaser coming in to perform their inspection can't be asked to perhaps wear a scarf to cover their mouth and nose. And they may have certain safety precautions they'd like to take. They may want to keep their shoes on as they walk through the house, and perhaps you want to ask them to wrap their shoes so they're not bringing in any contaminants from outside your home. Lisa and I spoke about the fact that it would be a practical step to have the walkthrough occur on the day of closing, perhaps in the morning, just to sort of minimize the amount of exposure that a seller might have to anything that the buyer may bring in and introduce into their environment. If the buyer does see any deficiencies when they do that final walkthrough, it can be dealt with through the lawyer's offices. So this does happen from time to time where someone doesn't know that the movers have hit a wall on their way out and then they've left a bit of a dent, or perhaps there's an appliance that has stopped working if the seller moved out a week ago and they just hadn't noticed. So lawyers are accustomed to negotiating holdbacks to make sure that the day of moving still goes smoothly for all parties. And there's no reason that that can't happen on the day of closing. Preferably from a lawyer's perspective, we would love to have those items worked out the week prior to closing, but it can happen the day of closing. And that does help minimize the exposure of a seller to any contaminants that a buyer might introduce into their home. Now, one area of law that's received a lot of attention, particularly because ongoing residential builds were declared an essential service, or at least have been allowed to continue by the provincial government, are new builds. And Lisa, you deal a lot with new builds, so I'll pass things over to you. And if you could just touch a little bit on perhaps how Tarion is involved in all of this. Sure. And what's being done to address some timelines.
Absolutely. So Tarion is basically the company that's employed by the government in order to enforce the New Home Warranties Act, which is basically statutory rights that a new home purchaser has with respect to how the home is built. That includes also when the home is built. As you know, if you sign onto an agreement to purchase a new build, it's usually years from construction when you sign that agreement of purchase and sale. And there's a schedule on that called a statement of critical dates. And that tells you when the builder is required to give you notice if they're extending what they think the closing date will be, what the timeline looks for that, what the maximum delay is, and basically compensation that's available to a purchaser if those deadlines aren't met. Now, very quickly after the state of emergency was declared, we saw builders sending out notices. So Tarion does provide for a bit of an out to builders if there's basically something that they can't control. So that's drafted Interion's documents as an unavoidable delay, and they've actually put their mind to this, and pandemic is included in the definition of an unavoidable delay. So basically builders are sending out notices at this point saying that unavoidable delay applies at this point. They can't speak to when your closing date is going to be, but it is being delayed. And there's no entitlement to delayed closing compensation as a result of that delay. So that being said, they're not stopped from completing the home. Like Janice said, they are permitted to continue construction. It sort of comes down to the state of readiness of the project. So I'm seeing that builders where we were maybe a couple weeks out from occupancy, usually they've got things pretty far along and things stay on course. Projects where we're a couple years out, they're definitely sending out those notices saying there is going to be an unavoidable delay. And really the delay is coming because they don't know when the new closing date can be. They have troubles getting trades in at this point, which I think is really having an impact on when they can get things done. You also have to keep in mind just the social distancing rules. Like picture a home that's being built, all of a sudden everybody in there has to stay 2 meters apart. So you're already drastically reducing the number of workers who can be in there and working in the same area. So all those sorts of things give way to delays in terms of closing. There's also things like municipalities who are no longer sending inspectors, so you can't necessarily get occupancy of the property. So those are the sorts of things that people need to recognize may come into effect as a result of the pandemic. So how it's going to go is going to depend on things like the availability of workers, how close the builder is to completion, and really ultimately how much they need to close the transaction in order to actually get the purchase funds into their bank account. So all those things are going to come into play there.
So I think, Lisa, you and I were talking about sort of the practical steps that people can take for both their commercial transactions and real estate transactions. And it really, I think, came down from both of our perspectives to making sure timelines were realistic, making sure that all parties were communicating throughout the process in the lead up to closing, just to make sure that everyone is still on track to close, and then having some understanding for certain circumstances which are not foreseen that might pose some obstacles to parties being able to close on time. At the end of the day, the contract is the contract, but as I think you mentioned earlier, Lisa, we're in unprecedented times, new waters, and so communication and goodwill between parties has never been so important, I don't think.
Yeah, I completely agree with you. I mean, there's no case law to say what would happen if somebody were to take a really principled stance and say, oh, you can't close because of the pandemic, too bad, I'm closing anyway.
Right.
The thought is that the court are not going to look kindly on that. They're going to be looking for equity and fairness in a situation such as this. So you do have to be very careful in terms of enforcing your contract and sort of taking a look at what's reasonable given the circumstances.
And then Danielle, I think, do we have some questions coming in from the audience? I'm sorry, I can't see the chat box on my end.
Yeah, absolutely. We do have some questions, and I'm going to get to those in just 1 minute. For anyone that does have a question, please use the feature just at the bottom of your window there, Q&A, and enter your question so that Janice and Lisa can address that. So the first question I have here says, are banks still able to commit to and fund commercial loans?
Yes, so that's a great question, because we did talk about the different steps that banks are taking to administer loans, but we are still getting fresh commitment letters in from banks. There are, of course, loans that are coming due and need to be refinanced or paid out. So banks are absolutely still taking on new lending work. They are entering into commitment letters. And although, it'd be great if we could have a little bit of extra time or more than was the norm to facilitate signing, those transactions are still going ahead at a very quick pace, and things are still flowing. Absolutely.
Great. And the next question here, I do feel like we touched on it earlier in the presentation, but maybe if we could expand on it just in case, is I don't have access to a printer to print documents. Can I still sign remotely?
Right. Yeah, that's something that I think people are starting to encounter, because I mean, I haven't had a printer in quite a while. So there are a couple ways we can get around it. We can send documents in the mail to people, so they have a document package and they can then sign that virtually in front of us and then send it back by mail. We can also allow you to come and use the virtual signing room that I mentioned. So somebody will set up the room ahead of time for you, and it will include your document package that needs to be signed, so they can get that all set up for you. You could even pick up documents from the office. We've got a secure Dropbox for if you want to leave things, all those sorts of things. So we definitely are willing to work with clients to work around that. And there's also even some smartphones you can even actually sign with your finger right on the smartphone. So depending on who the document needs to go to and what their rules are for signing, there's a variety of things that we can help you figure out to get over that.
Great. I have one other question here. A borrower had a commitment for a mortgage, then lost his job due to COVID. Now the lender is reassessing. Does the borrower have a right to enforce the commitment?
So I think we would look to the actual language of the commitment, but typically at that point it would be a binding agreement. Unless there were still conditions set to be satisfied, because of course the bank wants to make sure that what are called the ratios are in line, to make sure that you're still able to make payments on the debt that you're taking on. But my understanding is at the point that they have committed, unless there's a provision, they should be advancing on those funds. Lisa, do you have any thoughts on that?
I would agree with your comments there. I think it's going to come down to the fact whether you still meet the requirements under the commitment. I mean, it's very important to make sure that the commitment was properly signed. I mean, we do sometimes see some commitments that are even just signed by the borrower, not by the lender. So that's going to be one of those technicalities that we're going to look to make sure that you have sort of a leg to stand on. And I mean, following that, I think, again, you got a lawyer involved and we're looking to the reasonableness of the other party. And sort of the thought of what would this look like in a court situation if it were to get that far, and hopefully people can come to a resolution that way.
I think it may depend slightly on the nature of the loan as well. If we're speaking of a very simple, straightforward mortgage that is securing the purchase of a property versus a commitment for sort of a revolving line of credit or something like that, there may be some ongoing covenants saying that you will continue to present evidence of a certain income or a certain asset to debt ratio. So typically, though, whatever is outlined in the commitment will be what you can enforce. So it's just, as Lisa says, important to get a lawyer involved to give you an opinion on that specific commitment.
Great, thank you. The next question here is, my loan's maturity date is coming up. What should I do?
So I could jump in on this one. Basically, as much as it doesn't feel like it, it's sort of business as usual when it comes to those things. So your loan maturity date is coming up, but there's nothing that should stop you from taking the steps required in order to sign up for a new mortgage or renew the mortgage, that sort of thing. So head in the sand is not really an excuse in this situation. So unless there's sort of health risks that are stopping you from moving forward, definitely recommend you reach out to whoever you're dealing with in terms of a lender to discuss your options, maybe get a mortgage broker involved or speak with somebody at your bank. But you're definitely in a spot where you need to take some action. And it could even be something as simple as the lender deciding that they're going to extend the term for you, but for a certain period, maybe 6-month extension or something like that. Those are all possibilities that could happen. But it's something you need to be proactive and take steps to make sure that you get it done properly.
And often if you don't take those steps, the bank or your existing lender could auto renew your loan, and it may be on terms that are not favorable. So absolutely take the steps to be proactive and get something in place that you're comfortable with.
Yeah, your agreement could say that your interest rate is going to change in a way that you won't like if they're auto renewing it. So you definitely want to take steps.
Great point. And what about wills? Can they be done still?
Absolutely. So we've actually, this is another area where the Law Society and the provincial government have worked together, I think, although big thanks to the provincial government, to state that wills can now be witnessed virtually, provided that one of the witnesses is a licensee, meaning a lawyer or a paralegal. So, of course, holograph wills in Ontario, where you've handwritten out your will, signed and dated it, have always been available. But with this new bill having been passed, now when someone is witnessing a will in the presence of the will maker, what that means is that, Danielle, if you were making a will and I saw you sign it virtually over Zoom, as a licensee, I can be a witness, and I was in your virtual presence when I saw that done. Lisa, do you have a presentation coming up on this exact topic though in a couple of weeks?
Yeah, I think there's one 2 weeks from now on a Thursday when we're gonna chat about this very thing. Is it 2 weeks or is it next week?
It is still a very technical process, so it's worth making sure you're doing it right. But wills can still be signed, and we have new tools to allow us to do that properly with this this new legislation that was passed.
That's perfect. I'll take a peek at when the next session is so that I can include that in the closing remarks. Now, another question that's been posted here, I recently bought a business. The seller took back a promissory note for part of the purchase price. I'm worried about making payments. What can I do?
Right. That's okay. So that's a situation, I think, again, where it really behooves both parties to communicate openly. So for anyone who's watching, it's fairly normal when you sell a business, if the purchaser cannot come up with the full amount of the purchase price, what you say is, okay, pay me as much as you possibly can of the purchase price. I will take a loan back for the balance, and you can pay off the balance of that purchase price over X number of months or a year or 2 years, and you set out interest terms and things like that. So it's as though you've loaned money to the person who has purchased the business. Now, as you can tell though, if you're concerned that the purchaser is not able to make payments because business could be down in the current setting and the current times that we're experiencing, then I think it's important to reach out to the purchaser and just let them know that you're aware that they could be challenged to make those payments, or maybe wait until they have actually defaulted on payment or until they've contacted you. And it's very similar to the circumstances that commercial landlords or even residential landlords are facing. You technically have the right to enforce, but do you want to take that step? What is your security? Do you just have the right to step in and take back the business? In which case, would you want to do that in the current climate? Would you want to step in and take the assets? Again, probably not going to be super helpful right now. But what might be helpful if the business is going to be viable coming out the other end of the state of emergency is working with the buyer to make sure that they're aware that you know that their obligations will be continuing, but that perhaps you'll defer their payments or just sort of push back their obligations to pay and give them a couple of months of a break or a vacation from their repayment obligations. One thing I will say though is it's so important that both parties agree to those terms in writing. If I'm the buyer, I'm really nervous that the person I purchased the business from is going to come take it back from me. If I'm the seller, I'm really nervous that if I say something in an email to the effect of, oh, don't worry, you don't have to pay for as long as COVID-19 is going on, that in 8 or 10 or 12 months, I'm going to have a problem showing that, okay, no, now you do have to start paying me back. So it's important to be very specific and deliberate in whatever negotiations you're having between the parties, but certainly communication is going to be key to coming up with an alternative arrangement there.
And we have one more question here. So I'll just let the participants know it's your last opportunity to get some questions in. There is a feature when you put your questions in that you can actually check off that you're anonymous. So that way you can feel comfortable entering in your question there. So the last question we have right now is I listed my house for sale right before the COVID-19 outbreak. My closing date is in June. Am I still able to complete the sale? Do I have to allow the buyer to do their final walkthrough?
So yes, ultimately you've signed an agreement of purchase and sale. That's a binding contract. So unless there's some sort of amendment to that agreement that's negotiated, you should be taking steps to ensure that you are completing the contract. So giving them vacant possession on that closing date in June. Janice touched on the walkthrough situation. So as lawyers, we really like it if you get your final walkthrough as close to the date of closing as possible. And the reason for that is then you have a very clear picture of what the status of the property will be when you take it over. So we think that a really good way to deal with this would be a final walkthrough on the actual day of closing. So hopefully the seller has already moved out, and then you're not interacting with them, interacting with their personal belongings that are in the property, and hopefully minimizing risks yourself that way. Obviously, everybody exercising an abundance of caution in doing such a walkthrough. And I mean, it's ultimately at the buyer's discretion whether they choose to do so, and the vendor needs to be comfortable that the proper safety measures are being taken. But it is, if it's a right in their agreement of purchase and sale, then a seller doesn't really have a leg to stand on when they say, no, you can't come in unless there is an extraordinary circumstance.